9 accused in the Thabo Bester escape saga are expected at the Bloemfontein Magistrate's Court on Tuesday. In the last appearance, both the convicted murderer and rapist Thabo Bester and Dr. Nandipha Magumana appeared virtually from Kgosi Mampuru Correctional Facility and Kroonstad prison. Since then, the 4 accused were denied bail, while Natassja Jansen was released on 10,000 rands bail. Meanwhile, one of the police investigators in the Thabo Bester escape case, Brigadier Jackson Mkhaulesi, died.
It is not clear if Dr. Nandipha Magumana and the convicted rapist and murderer Thabo Bester will appear physically with other accused at the Bloemfontein Magistrate's Court. In their last appearance in May, Magumana and Bester appeared virtually. Bester's lawyers were not happy with Bester's virtual appearance and told the court that it makes it difficult for them to consult with their client.
Also looking cautiously as to whether what will their appetite be, but tomorrow they might appear virtually and they might be cooperating with the process, but up their sleeve is that they are waiting, or they are still go to the Supreme Court of Appeal for the appeal of the outcome of their case in the Bloemfontein High Court.
Magumana has filed an application for leave to appeal the Free State High Court judgment that dismissed her urgent application to declare her arrest in Tanzania unlawful. The High Court found that Magumana did not resist during the handing over process, as she stated that she wanted to return to South Africa to her children. In her papers to the SCA, Magumana insists that it is a matter of principle that consent cannot be given to an unlawful conduct. Her lawyers earlier argued that her arrest and deportation had been carried out as a disguised extradition.
Basically, we're going to hear that she might extend that suspension for bail application because we're still waiting for the report for leave to appeal, which is not yet been received currently. Then for accused that are coming on another ones, as the accused number 9 who's been joined. The accused number 9, on the first time, he only explained to the court that he needs an attorney.
So far, 2 accused, Magumana's father, Zolile Skeleni, and Natassja Jansen, are out on bail. Dr. Nandipha Magumana abandoned her bail application in pursuit of an application to nullify her arrest. Meanwhile, the latest accused on the matter, Zanda Moyo, is expected to have a legal representative. Moyo will be appearing for the second time since his arrest. He is the 9th person to be linked to the Bester's escape from Mangaung prison in May last year. Makhalama SABC News, Bloemfontein.
Right, for more on this, then, we are joined by attorney and legal analyst Ulrich Roux. Ulrich, it's always a pleasure to see you. Thank you very much for joining us here on SABC News, sir.
Hi, good evening. Thank you for having me.
All right, let's start here. I mean, what do you expect tomorrow? What are you expecting from the proceedings tomorrow when the 9 accused do appear again? I suppose I should ask, where are we really at this point?
Well, tomorrow will be another preliminary appearance. The matter is not yet ready to be set down for trial, and no evidence will be laid tomorrow. I think what we can expect is that the state will most likely seek another postponement in order to complete the investigation. And once the investigation is completed, then the matter would then draw closer to trial stages, and the matter could then possibly be set down for trial at a later stage. But tomorrow will most likely just be a postponement, with no findings tomorrow in court.
Yeah, I know you say we shouldn't be expecting anything that's leading to the issue of a trial, but I do want to talk about the seriousness, though, of aiding and abetting of a convicted criminal to escape. I mean, if one was to listen to where it seems Nandipha Magumana's legal team is going, one would be swayed perhaps to believe that it's not as serious a crime. Let's talk about how serious the issue really is.
No, it is very serious. I mean, she's going to be accused of aiding and abetting a convicted 11, as well as obstructing the interest of justice in that she has assisted him to escape from prison. So definitely a very serious offence, and an offence on its own that could carry a prison sentence. So I don't think, they should take it too lightly, but they would only be able to really determine the strength of the state's case once they obtain a copy of the docket, and then they can start preparing themselves for the trial in the matter. She has abandoned her bail application, which, she will remain in custody.
Yeah.
She's indicated that she wants to take the High Court decision to set aside her arrest on appeal.
Yeah.
So one would have to wait and see what happens with that matter as well.
Was that a good move on her part in terms of abandoning a bail application for that particular reason?
Well, it could have been a strategic move. We do see a lot in the industry that people abandon their bail applications and they wait for a copy of the docket first before they then do consider launching a bail application again, because then they can determine what the strength of the state's case is against them and what the case is that they need to answer to. And if it turns out that the evidence obtained against them is not, very strong, and that they fancy their chances on, securing an acquittal and being found not guilty on the charges, then one could most likely see a bail application being launched again. Pertaining to her application, the Free State High Court of having her arrest in Tanzania set aside.
Yeah.
I think it's purely an academic exercise, because should she now go on appeal, the High Court has of course dismissed the application. Should she go on appeal and she is found, it is found that her arrest was indeed unlawful, and she is released from custody, then one could just expect the South African Police Services to immediately arrest her again upon her release. So I don't think, strategically it's such a wise move to now approach the Supreme Court of Appeal, and one would have to wait and see if she does indeed proceed with that. But on the main charges, they have to wait for the police to finalise their investigation, and then they can proceed to set the matter down for trial, where actual evidence will be led during the trial.
Why do you think they would have gone this route? I mean, the fact that you raise, correctly so, the fact that, even if she were to walk based on the technicality of, what was done during her arrest, the South African police can still arrest her. So what was the thinking really behind that particular strategy by her and her legal team, I assume?
Well, I'm not sure, to be honest. One would have to ask her legal pertaining to that. But I think on what we've seen and what has been circulated throughout the media, she does face an uphill battle in this matter, and it seems as if the evidence that has been gathered against her and the other accused in this matter is quite strong, and it is quite damning. So, the only reasoning behind her application to the High Court then is to say that, well, she should have never been arrested and she should have never appeared in court from the outset. But once again, that should she be released, she will just be arrested again because she is now implicated in a crime. Thabo Bester, of course, is a different story. He's now continuing to serve his sentence, which was handed down on a conviction of rape and murder. And he will continue to serve that sentence. So even if he had to apply for bail in this matter, it wouldn't make any sense whatsoever, as he will remain in custody on the matter he's been convicted of already. So yes, the state will be given an opportunity now to complete their investigation. They of course cannot just ad nauseum, take as much time as they want to, because the accused do have a right to a fair and a speedy trial. But one can expect the investigation to be completed quite soon, I would imagine. And then once the disclosure of the police docket takes place and the accused can see and peruse the evidence which the state has against them, they would be in a better position to strategically decide whether they want to take the matter to trial or whether they want to make representations to the Director of Public Prosecutions in an attempt to have the charges withdrawn, or whether they would consider a guilty plea and possibly try and argue for a lesser sentence to be handed down. and we would have to wait and see once they do receive the docket what strategic decisions they make.
And the next question is really just, out of interest, and certainly one that has been spoken about widely in public domain. I suppose this is more of an admin issue. Of course, we've seen both Thabo Bester and Nandipha Magumana appearing virtually. And I understand that, some of the reasons that had been presented for that was, the issue of cost implications and logistics. Is that a regular thing? Is that normal? Is that something that it can be and should be expected? Some people were saying that, it seems like, again, some sort of unfair treatment, unequal treatment. I mean, what do you say to that?
No, it's not unfair treatment whatsoever.
Yeah.
We see this more often in our criminal courts, today, that if the matter is purely going to be postponed, then it's not necessary for the state to incur all of those costs. And in this instance, also incur the risk of a possible escape from custody, given the charges that these accused are facing.
Yeah.
And it would just make sense for it rather to be a remote postponement where they remain in custody and the matter is postponed by a video link. So it's not out of the ordinary whatsoever, and I don't think people should read more into it other than that. It's an attempt by the state to mitigate their risk and to avoid unnecessary costs being incurred in having to transport those detainees to court and back when it's not necessary to do so.
All right, Ulrich, a pleasure talking to you as always. Thank you very much for your time.